Testing, Judge Microphone 1. Testing, Judge Microphone 2. Testing, Judge Microphone 3. Testing, Judge Microphone 4. Testing, Judge Microphone 5. Testing, Judge Microphone 6. And testing, Judge Microphone 7. Testing, appellant mic. That is appellant mic. Testing, appellee mic. I'm still redlining. Okay, appellee mic. Appellee mic.
name is Michael Skolnick, and we represent Mick Land Development.
My name is Phil Saucier, and we represent the town of South Berwick.
Thank you. And Attorney Skolnick, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you. May it please the court. The matter before the court concerns limits of delegated planning board discretion, and specifically whether the town's legislative body may delegate broad discretion to a planning board to impose conditions without meaningful standards or guidance. Administrative boards apply standards adopted by the legislative body. They do not create new ones. The South Berwick Planning Board expressly found that Mick Land Development satisfied every applicable ordinance standard, including those governing traffic safety, access, and circulation. It did not find that the subdivision violated any ordinance provisions whatsoever. Yet the board imposed Condition 6, restricting access to a public road based on generalized safety concerns raised by abutters. Once the board found full compliance with the ordinance, it lacked legal authority to impose a condition that contradicts its own findings and mandatory provisions of the ordinances. This case must be understood in the proper context. Every objecting abutter purchased into a subdivision whose approved Phase 2 plan expressly reserved a 50-foot connector for Phase 3. The Phase 2 plan calls out a 50-foot future connection. The deeds for abutting parcels expressly reserve the right-of-way. The connector was specifically required by the planning board during Phase 2 approval, and the road was approved with the condition that it connected to Phase 3 and later accepted as a public road. The continuation of Meadow Pond Road into Phase 3 was not new. It was planned, required by the planning board, approved, and recorded with the registry. Condition 6 effectively eliminates that required connection without identifying any ordinance violations. The condition does not even advance the safety rationale it's offered to justify it. The record shows that sidewalks exist entirely through Phase 1 and Phase 2 of the developments. The traffic studies affirm adequate site distances and a level of service reaching level A. The board's own findings concluded that the safety standards were met. The findings did not address the existence of sidewalks, nor do they reconcile how preserving a 4,500-foot dead-end road, as well as creating a new dead-end road in Phase 3 of the development, enhances safety. If children play in a public road despite the presence of sidewalks, that is a behavioral concern. It's not an ordinance-based traffic safety deficiency. The ordinances regulate roadway design and circulation, not neighborhood recreational patterns. If the concern is pedestrian safety, sidewalks are already in place. If the concern is circulation safety, connectivity is improved by the connection to Meadow Pond Road itself. Condition 6 does not implement ordinance-based safety standards, it actually directly contradicts them. The issue before the court is not whether neighbors are uncomfortable with additional traffic. It's whether a planning board may find full compliance with the adopted safety standards and nevertheless impose a condition that conflicts with the ordinances and undermines its own prior approvals. It's all reliant on board's delegation of, quote unquote, protecting health, safety, and welfare. Maine law does not permit that result.
Thank you. I see that the green light is on. I'm looking at the ordinance, and it felt to me like your argument was that they having found that it meets conditions, that the board doesn't have any power to modify the plan or include any conditions. Is that your argument?
No, that's not. The board does have the authority to impose conditions. However, this court has said through its precedent that the ability to impose conditions has to be grounded in the ordinance. It has to be more specific. The ordinance has to provide guidance on how the board can do that. Here, the board bases its imposition of a condition based on a broad grant of health, safety, and welfare, and that's an unlawfully broad grant of authority.
Well, section 121-12 of the subdivision ordinance talks about modification approval and says the subdivision, one of the conditions, subdivision will not cause unreasonable highway or public road congestion or unsafe conditions with respect to the use of the highways or public roads existing or proposed. That seems to me a broad grant of authority to look at road congestion and factors to be considered there, and that they can modify it as they find appropriate.
Thank you, Justice Mead. But if you look at the findings of fact itself, the findings of fact, before it was remanded back to the board for additional findings, they specifically say that that condition was met. And then it relies on a traffic assessment that was provided that shows that all of that standard was met as well. The board then, after a long history here, just decides to put that condition within that standard. But if you look at the remanded findings at appendix page 47, you'll see that that standard was met, and it actually removes the condition from that standard itself. It's not based, the condition was just thrown at this application after the fact. It does not apply to that standard that was actually specifically designated as met by the board.
So you're saying that at the initial decision-making process, there was no standard at all?
At the initial decision-making process, the standards, the site plan review standards and the subdivision standard is what guides the board.
So you're saying we can't read their findings and conclusions of law as saying, you meet these road conditions that we apply with this condition? You can't possibly read that as its ruling.
That is not the way it is written, no. It's written as this standard is met, however, we're going to impose this condition. And the reason for doing
However, so does it say, in spite of us finding this, we are going to impose this condition? It's not that explicit, is it?
No, it does not say that. However, the broad grant on top of it, specifically, once an ordinance standard is met, there's no authority to impose a condition on top of it. The ordinance doesn't allow non-factual based conditions to be imposed.
But isn't it an interpretation of what they're doing? In other words, whether, and this goes to following up on Justice Connor's question. I mean, it depends on how we read it, whether they're saying it was met, period, and unrelated to that, we're going to impose a bunch of conditions, or whether they're saying it was met with this condition that we're imposing.
However, if you review the remanded findings, it says it was met. It does not say anything about the condition based on that standard in the site plan review ordinance. That condition is much later in the findings, not tethered at all to that specific performance standard under the site plan review ordinance. That was after the initial findings, based on the remanded findings, that was taken out of the site plan review standard and just imposed later on the project itself generally.
Well, the board in this case heard from residents, people who had knowledge of the road and expressed concern over congestion and safety and curves, and as opposed to these two alternatives, which would be the better of that. Is there any reason why, with that eyewitness view, that it would be inappropriate or unavailable for the board to modify the previous conditions or to establish a condition?
The board has to rely on the competent evidence in the record. Here, this court actually has a great opportunity here to clarify what constitutes competent evidence.
Well, we've already done that. We said substantial evidence exists if there is any competent evidence in the record to support a decision, 21C Brand.
Absolutely, but utter speculation without supporting data.
How is it speculation if they actually drive this and exit the road themselves? Don't they have personal knowledge that they're speaking about in these hearings?
They do have personal knowledge. However, that can't be, I understand that the board weighs the evidence, and this court isn't supposed to weigh the evidence. However, when we look at competent evidence in the record, that is not what all the precedent says would be competent evidence. If the town...
They said it's really hard to get out of this exit, and we do it.
Every day.
Why isn't that enough?
That's not enough because it's not tethered to any ordinance-based standard whatsoever. We look at all
That's a different argument. I mean, that's really, you're saying this isn't the subdivision itself. This is outside the subdivision, et cetera. But that's different than saying that people's personal knowledge of what happens on the ground is not competent evidence of what happens on the ground.
It is evidence that should be considered by the board, but all of the precedent in the case law specifically, and nothing can be pointed to by the town that ever relies on simply just abutter testimony to disprove an application. There's not one case that can be cited that we know about or the town knows about that a board specifically relies solely on abutter testimony to disprove an application.
What additional evidence would you look for, if not for personal experience of the people who live there?
We would look for anything whatsoever what we believe is competent.
So you have
and
to
that's-
have the DOT saying it's a condition C as opposed to a condition A? Is that the evidence you're saying you have to have on a traffic claim?
When we look at the evidence that we do have, there's only testimony from abutters that say there's windy roads, my children play in the street, and we would like less traffic to come down a already public road.
And it's really hard to get out of this exit. They testified to that, didn't they?
Yes, but when you look at all of the expert testimony, and there's an abundance, and none of it has been refuted.
Isn't it common sense, though, if you develop a whole nother part of this area, you're going to have an increased traffic flow? And doesn't that raise concerns? And aren't those legitimate concerns?
Absolutely, they're legitimate concerns, but there were concerns that were considered by the planning board during phase 2 of the development. This was an explicit connection that was conditioned
Well, that's really a different
by this.
argument from the competence of the evidence, though.
So you're saying they had to go out and hire an expert to come in and then present a report on their behalf, and that's the only way it could be considered by the board?
That is not what I'm saying. I am saying that there needs to be some sort of competent data whatsoever. They have to point to some police report, anything at all that shows besides that they don't want their
So they
kids
have to
playing in
have
the
a
road.
police report showing there was an actual accident before we can say that their testimony is enough?
There is just nothing in the record whatsoever that shows that this road is not safe as is. It's a public road that was accepted by the municipality. It was windy because that is, and it was testified by our traffic engineer that the windy roads were designed that way to actually slow traffic. Everything that went into engineering the Phase 2 road and the Phase 1 road was designed to limit traffic congestion. It was the planning board themselves that came in that put the condition on this road that it connected to Phase 3. Now what we're doing, after all of these folks bought into this common scheme of development, understanding that this road was going to connect to Phase 3, and now they're going in and saying, we don't want more traffic.
Thank you, counsel.
Thank you.
Attorney Saucier?
Madam Chief Justice and members of the court, may it please the court, and apologize for my voice. It's been out for a couple days. The questions in this appeal are really two: whether the South Berwick Planning Board had the authority to place a condition on its approval of a 35-lot subdivision, and whether its decision to place that condition was supported by substantial evidence in the record. I'd say competent evidence in the record. And in both cases, the answer is yes. The Superior Court rightly rejected the applicant's argument, or the appellant's argument, and found that the Planning Board considered all of the evidence before it to determine that there existed safety concerns with the road that supported condition number 6, a sign that said emergency access only or no throughway. There is both specific and inherent authority for the Planning Board to impose conditions on its approval. The Site Plan Review Ordinance, there are two ordinances in play. The Site Plan Review Ordinance that pertains to criteria and standards gives the Planning Board the authority to attach conditions that it finds legally necessary to further the purposes of the ordinance and to protect the long-range health, safety, and welfare of the town. It must be tied to specific standards. The Subdivision Ordinance also gives the Planning Board the authority to impose both conditions of approval at the preliminary stage and make any changes or modifications at the final subdivision stage. There's also inherent authority for boards to attach conditions, and that's in the case of Reid Belgrade Lakes. It was a case that dealt with the state site law, but in that case, the court noted that the board has discretionary authority, or boards, to adopt conditions in an application to address deficiencies rather than just have a series of disapprovals over time. And finally, the conditions must be reasonable and tied to specific standards. In this case, the Planning Board did tie it to specific standard 121.12e in the Subdivision Ordinance, that the subdivision will not cause unreasonable highway or public road congestion or unsafe conditions with respect to use of highways and public road. there's competent evidence in the record to support the imposition of the condition based on testimony. There was, and that's in the record. Access to Sandville, and this is from the testimony, would be dangerous and would have negative impact on the subdivision. The roads are curvy and very winding. Visibility is not great. Testimony that there are blind spots, that there are numerous children that live in the subdivision. Many ride their bikes and people walk in the streets. And specifically concerns with visibility exiting the Meadow Ponds Estate subdivision onto Knights Pond Road, that exiting was very difficult. The board heard this testimony over 13 different public meetings, a site walk, and many public hearings. Thus, while the board did find that the material presented would ensure safe motor vehicle passage, what the board found, as you saw in the record, is that the road and resulting vehicle speeds did not provide assurances to pedestrian and bicycles without mitigation, and so they imposed the condition based on that testimony. The board weighed that evidence. The courts did not weigh the evidence. The board carefully considered both the applicant's expert testimony, which is allowed.
Green light is on.
Yeah. Yes.
What is your response to the argument that if you look at the decision itself, the condition isn't tethered to the road requirement, and that according to them, they found everything was met, and they tacked this on without any authority to do so?
Well, Justice Connors, I'd respectfully disagree with that, both in the initial decision, where the board found specifically that the condition was tied to the subdivision standard related to traffic, but also on the remanded decision where the board went through its various findings and rationale. What the board found specifically in the application was that while it was met, condition 6 was required to ensure that it was safe for pedestrians and bicycles. In other words, it was explicitly tethered, in my view. They would not have made that decision but for that standard. And it was certainly part of the discussion. If you look at the record and the transcripts of that discussion, it's clearly in the context of road safety.
Well, it's not very, we talked about how it wasn't very explicit to say it was not tethered, but it's not very explicit about how it is tethered. It doesn't say you meet this if we impose this condition.
It's flat out says the standard is met.
Standard is met, and then if you go on to see under the findings of fact, and then there's the conclusions of law provision, and under MSP 2203, so this is record 48, appendix 48, the original application. The board says the standard was met, but then goes on to say received testimony about traffic and neighboring residents on pedestrian and bicycle. And so it says, while the materials do ensure safe motor vehicle passage, the vehicle speeds do not provide assurances to pedestrian and bicycle traffic without mitigation. So in other words, it's exact issue I think that the court in Reid Belgrade Lakes was getting at, which is rather than have a series of disapprovals, if a board finds that a standard was not explicitly met, the board can condition its approval to say, yes, this is met with this condition.
Is there a particular quantum of evidence that would be necessary after the board gives site plan approval and then revisits and takes additional testimony? Does it start with a presumption that the proposal meets the standards, and then something happens in the meantime? Is there a burden on that, or does it go back to the original weighing of all of the evidence together? Is there a burden of proof to try and add a condition that wasn't deemed necessary the previous time around?
So no, I mean, the condition was deemed necessary the previous time around, and on the remand, and correct me if I'm wrong, they did not take additional evidence. So in other words, it was remanded simply to provide findings of fact to support its conclusion, which is obviously somewhat typical. So what the board did is they did review and cite to evidence in the record that they had received under the first. So it was the same condition. They provided additional support, support to the record as the court asked them to. So it was the same decision. What I would say is also this is very much similar, and I think one of the questions I think you're getting at is the sort of testimony and the sort of weight of that evidence. And one of the things I heard was this argument that somehow neighborhood testimony needs to be sort of cited specifically to some expert, either a police report or something like that. And that is not what I think the courts have ever said.
What are we to do with the fact that, I mean, this is a phased development, that this road was approved in phase 2, and it was approved, everybody knew. I mean, the owners in the existing development took title knowing that this third phase was supposed to happen and that the road would continue through. I mean, doesn't that really weigh against approving this or affirming this?
Well, it's a good point.
How can they then come back and say, yeah, but we don't want them to?
Well, they can say that, but they can say that, but the board actually did approve it. So I think that's one of the things I would say here is that if the phase.
Yeah, but they didn't approve it by using the point of ingress and egress that was intended. And it feels a little weird that these homeowners in Phase 2 who take title knowing that there's supposed to be a Phase 3, that this road is going to continue through to that development, then they come in and say, yeah, but we don't want it to.
Right.
We like our cozy little neighborhood, and despite the fact that we knew when we bought this that there was supposed to be more development, we don't want that to happen.
Right. And it's a very good point, Justice Stanfield. I've thought a lot about that. But Phase 3, each application sort of stands on its own, if you will. So Phase 1 and Phase 2 were approved. Phase 2.
There's some debate whether this is a phased development or not, right?
Right.
So it may not even be a phased development within the definition.
It may or may not, Justice Connors. So in other words, what Phase 2 showed on the plan, if you see it, is a right-of-way. That's not unusual, right? So a potential future phase. And there are various reasons why phases go forward or not, or future development, but that did happen. There was a right-of-way set aside, and there was a deed. So, but that Phase 3, which is what we're looking at here, or the new Samville Estates, whether it's a phase or not, then has to stand on its own, right? So it wasn't
is it your view that we
pre-approved.
give essentially no weight to that? In other words, I'm putting aside, it's not a competence issue, but we have all these homeowners coming in saying basically, we don't think the road is safe, we think this, we think that, we don't want more traffic on this road, and yet. That was sort of how it was all, at least arguably all planned. And you're saying none of that matters for consideration of
No, I'm not saying none of it matters. What I'm saying is under this application, so in other words, each application stands on its own. This application came in for a 37 and then 35 lot subdivision using the set-aside right-of-way. The board then looked at all the evidence in the record, including the resident testimony and the experts, and then approved it.
Yeah, but doesn't that go to the issue of whether, it's not a matter of whether it's the kind of evidence upon which reasonable people would rely, but more whether it's really relevant. In other words, if the residents are saying, yeah, but we don't want anyone else here, I mean, is that really relevant, is my point.
Well, I think it's relevant to the traffic standards. It's relevant to any, so in other words, this application had to stand on its own. Right, so there could have been other standards that even though residents bought into the first two development, didn't mean that the whatever was going to be out there, whether it was going to be 12 new houses, one new house, right? There was going to be something. And that application had to come before the planning board, and the planning board was going to review traffic impacts, environmental impacts, all the other kinds of things that it needs to apply, and may have had standard conditions as related to that. So the planning board did that in this case. They weighed that evidence. I think it is important to note that there is actually going to be a road. So what we're talking about in terms of Condition 6 is a sign that says emergency access only, no through vehicles, right?
So what was the argument about how it violates the dead end rule and your response?
I don't understand the argument.
Okay.
So that gets to what I previously said is there actually will be a road here.
It just
and there's no
flips
lockbox.
which is the emergency and which is the primary road.
That's right. That's right. So from my understanding, and I don't think there's anything in the record that suggests there's any kind of barrier, physical barrier, right? So in other words, there'll be access through the existing Meadow Pond Road into the new subdivision. There's another access off the other side on India's
So what about the
Industry
argument
Road.
that if you make Industry Road the primary, DOT is going to make them put in all kinds of costly changes to that road in order to make it safe?
That may or may not be the case. That would be something that would have to be reviewed by the DOT and the town of Berwick, for that matter.
So basically, so sad? Are you saying it's irrelevant?
I mean,
You were going to say something else.
yeah, I mean, so this is what the South Berwick Planning Board determined, right? And so if there are other permits that are required or amendments to permits that are required, that's not within the South Berwick Planning
Right, they have
Board's
to go to
jurisdiction.
South Berwick now.
Or Berwick,
and,
yeah.
and try to get some approval from, or Berwick to find some approval, right?
Right.
Do we make anything, at least I think I saw in the minutes, there was some discussion at one point, I think they were the July minutes, where there was a disagreement as to whether or not the Meadow Pond Road was supposed to be the primary exit or whether it was not it was supposed to be the alternative.
Yeah,
That the board didn't seem to be consistent in its view as to what the point of ingress and egress was going to be.
I think the board was grappling with the safety concerns that articulated throughout its decisions and its meetings, and that clearly was one of the topics of conversation, both in front of both boards, but in front of the planning board on multiple occasions, which is what way was the traffic going to flow. There was earlier iterations where you might see where they were talking about maybe a lockbox or knockbox on one end of one road to prohibit a gate or something like that. So they were going through various machinations to deal with the concerns they were hearing about. And ultimately, what this board determined on a couple different occasions at this point was that that the road should be built, access on both sides, but it should be a one, essentially only emergency access on one side.
There don't appear to be additional
I have nothing
questions. Thank
further.
you.
Thank you.
And Attorney Skolnick, I understand you reserve 3 minutes for rebuttal.
Thank you. I do want to start off by saying that the town throughout this process and the Southern Maine Planning and Development Commission, as well as the town's third-party reviewer, did recognize this as phase 3 of the development during their review.
Does it matter? I mean, really, what he's saying is it doesn't matter whether or not it was known to be a phase 3 or not, that it still has to stand on its own and that they can independently review the safety of the ingress and egress.
Absolutely, but they do have to look at how the connection was approved, as the bench said.
Well, it really just shows a right-of-way. It doesn't really say, oh, and by the way, this is going to be the means of access to phase 3.
However, not allowing it to connect does fly in the face of the ordinance's intent specifically.
But
The
you're
ordinance,
not arguing estoppel, are you?
No, I am not.
So if they're not a stop, doesn't that mean they can make this change based on what conditions have shown by the testimony that has been presented to them?
However, what this condition does, it directly contradicts the intent of the ordinance, which the legislative body put in front of this board to enact.
How does it contradict the intent of the ordinance?
Because it contradicts the connectivity that's supposed to happen to abutting properties. What this effectively does, sure that there is a road there that's allowed for emergency access. However, it functionally limits all public, from a public road to free flow
Sure.
to a different
It
property.
disconnects them as a single development.
And that's extremely contradictory to the intent of the ordinance. And
What part of the ordinance is that contradictory to?
the subdivision standards specifically require for connectivity to adjacent properties. What this condition is doing, it's not allowing a new development, which from their backyards, they can specifically see a private road, and this condition limits all access to a private road that's been accepted by the town. And simply doing
Well,
so.
they can come in and out of Industry Road, right?
But what they're doing is they're directing it through now a commercial road that is pretty much an industrial park in a different municipality.
And my understanding was Industry Road is not a public road, or is it?
My understanding is that it's a private road, absolutely. It
Does
is.
that pose a problem here?
It poses a problem functionally, however, our client does have rights to that
Okay.
road.
So in that sense, it really doesn't.
Absolutely. But I do want to
I mean,
reiterate.
sometimes you will look at a road and you can't get to the road. Are you saying that's bad because somehow it's configured so you have to go through a different road?
When the application before the board was specifically permitting that connection and the Phase 2 allowed that connection and intended for that connection, now what they're doing is closing off that road, making school buses, garbage pickup, everything, drive through 2 other municipalities and through an industrial park just to access this development.
Thank you, counsel.
Thank you.
Thank you, counsel. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. As well, I understand, Mr. Skolnick, that this is your first appearance in front of this court, and as is our custom, we would invite all counsel to come back into the conference area and take the greetings of the court. Good morning, you can be seated. And the matter before the court is Cumberland 25-357, estate of John Carter versus Ann Martin. We are being streamed on the web, both by audio and by video. Before we begin the argument, I would ask counsel to identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Madam Chief Justice. Carl Woke and Richard Lucas for appellant Ann Martin.
Hello, Your Honor. Cody Mason representing formerly John Carter, now the estate of John Carter.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you, Madam Chief Justice, and may it please the court. This divorce appeal is defined by the following facts. Mr. Carter died before a final judgment was entered by the divorce court in this case. Mr. Carter did not die during the post-judgment appeal period. Mr. Carter did not die during the pendency of an appeal, nor was there an imperfect final judgment that had previously been entered by the court and was corrected by the trial court posthumously. The only judgment in this case, the only final judgment in this case, was entered post-mortem, regardless of whether that judgment could have been entered sooner. Because the final judgment was signed and entered after Mr. Carter died, it was executed after nature had already caused the parties' marriage to definitively end. If a divorce ends by natural causes before a final judgment is entered, the overwhelming majority of states would hold that the divorce case abates, and that is currently the law in Maine as well. The district court made a mistake in issuing a final judgment after losing jurisdiction over the parties and compounded that mistake by retaining jurisdiction and declining to grant relief from the judgment when informed of Mr. Carter's death. This court should reverse the district court's decision and order abatement of the divorce action consistent with Maine law. And that's the end of my opening, so I'm happy to hear questions from the court if there are any.
In the proceedings in front of the district court, my understanding is that obviously the uncontested divorce hearing was on June 6th. The divorce judgment was signed, I believe, on July 3rd. Is that right?
That's correct, Your Honor.
At the time that the divorce judgment was signed, the judge had no way of knowing Mr. Carter had died, right?
There was no formal filing before the court. That's correct, Your Honor. But he had passed away.
Okay. But is there anything in the record below that indicates the date of death, or for that matter, gave the judge the opportunity to deal with the issue that is now being presented to us?
Well, that would be the formal opportunity, Your Honor, was the Rule 60B motion that did apprise the district court of Mr. Carter's death.
And that was filed by Ms. Martin.
That's correct, Your Honor.
And that was denied, I believe, the very next day after it was filed, right?
It was denied without an opposition from Mr. Carter or Mr. Carter's estate. And at that point, Your Honor, what I believe to be the case was because there had been a divorce entered, it would not have been possible for Ms. Martin to obtain a certificate of death or something like that in order to...
But you didn't file a suggestion of death in the district court?
Not before filing the Rule 60B motion.
Okay.
But the issue before us, when we, sitting as an appeals court, we look at the trial court record, the four corners of the record, as to what was before the judge below. I mean, we can't accept facts for things that happened after the case. Otherwise, every party would come in and say, well, that happened at the trial, but after the trial, this is what happened. So in this case here, we have the motion, which says that John died. I think there are two different dates given, but usually, death is a binary thing. You're either, it's one way or the other. Is there any issue here about the fact that John died on June 26th, was it?
I think it was 27th. And again, the nature of these things is that Ms. Martin doesn't necessarily know the moment that nature takes hold.
But she can still file the suggestion of death on the record. I mean, under the rules, it doesn't have to be, it could be either party.
Right. I'm not sure that there's any authority, Your Honor, that I'm aware of where the actual occurrence of death and whether it abates the case turns on the specific filing of any motion by any party under the circumstances. I mean, this happens in a pretty rapid succession of events where the parties become aware, well, Ms. Martin becomes aware of Mr. Carter's demise. The order is issued not long after that. I think it's a matter of days. And Ms. Martin, for her part, tries to correct the record and apprise the court of what had happened as expeditiously as possible, as soon as we could get a post-judgment motion out, or a motion for relief from judgment out. So I think that to say that the court doesn't have notice of the...
Well, are
Why
you
didn't they
saying it was,
note?
there was no way you could actually provide evidence, like an affidavit or a death certificate?
Well, at the same time, I'm not saying that there's no way. I'm not saying that's impossible. I am saying that that doesn't seem to be the basis of the court's denial of the post-judgment motion. The 60B...
We understand that that's not the basis of the denial, but it does feel like there's no evidence. We're struggling with there's no actual evidence of the death in the trial court, record evidence. Now, there is a suggestion of death and a death certificate that was filed with this court. And I take it that you would certainly agree that the death occurred at some point between June 6th and the date the divorce judgment was entered, July 3rd.
I would hope no one's disagreeing with that, Your Honor, because that is what happened. And to that point, I think that the court's appellate review function is also to adjudicate and decide when the trial courts have jurisdiction over the matters that are being decided by the trial courts.
When we have evidence.
Well, Your Honor, again, the note, the appellee has
Now
submitted.
we have evidence in front of us,
Right.
which isn't usually how it goes, and you file a motion if you want to produce evidence in front of us.
So again, the basis for the appeal is the denial of the 60B motion as well as the
Can we take judicial
verdict.
notice in our decision of the death certificate, since it was filed with us in any event, and then sort of impute that back to the district court?
I suppose I don't see any issue with that, Your Honor, and I also would think that the court would still exercise its appellate authority to make a ruling about the scope of the trial court's subject matter jurisdiction when a party has in fact died, regardless of when a particular notice or document is filed with either the trial court or the appellate court. The timing of the notice of Mr. Carter's death doesn't affect the fact that he did in fact die before a final judgment had been entered, and that is an issue that warrants redress from this court because it speaks to the very subject matter jurisdiction of the trial courts in adjudicating divorces.
If we can jump to the next issue, we have the judge says on the record after this, I'll go down and look at it for the paperwork, I'll sign off on it. If there are waivers of appeal from both parties and file the divorce judgment, the divorce is judgment and the divorce is final as of today. Almost making it ministerial for the actual signing. He's making an announcement on the record. The parties could presumably rely upon that.
So the court also says, and I'm looking at appendix page 46, if there are waivers of appeal from both parties in the file, the divorce is judgment, and the divorce is final as of today. You can get a certified judgment upon request of the clerk for a small fee. So that implies that there's some conditional aspect to that. I think that the issue I have, Your Honor, is with respect to whether the court is going to rule based on a distinction between a ministerial act and a judicial act. When the court has talked about ministerial acts, I think it tends to be more in the context of 80B or 80C appellate decisions, and the court's looking at the question of whether the state actor or the agency still might have to do a ministerial act yet, like issuing a permit, before the appeal is perfected for the purposes of this court hearing it. The court doesn't necessarily. I think banks, the state of banks, is the most clear resolution of what is ministerial versus not. The court has said.
What do we make of it? We'll talk about the waiver issue in just a moment. The court just said Thank you very much. This divorce is final. You folks are divorced. You can go out and marry somebody else tomorrow. Would that be invalid, ab initio?
I don't know if it's
Because the
invalid.
court hasn't put wet ink on a piece of paper?
Well, I think the reality is we're bound by Rule 58. We're bound by this court's interpretation of Rule 58 until something else comes down the pike. And the reality is that litigants and courts benefit from knowing the decisive moment when a judgment is, in fact, final. The court has said that it is the signing of the order.
What is it that prevents the trial court from entering a judgment nunc pro tunc?
What is it that prevents the court from doing it in this instance?
And saying, that I find that the final judgment was June 6th, not the date that I'm signing this thing. What prevents them from doing that?
Well, I think it's just the mechanism of what that phrase or what that order is meant to accomplish. Typically, not just in Maine courts, but in other jurisdictions as well. The question is whether there is a correction to the record, as in there was a final judgment that needs to be corrected, and the parties in the court wants to make sure that the original final judgment is still effective as of that date, notwithstanding the correction. But the idea of reaching back in time and deciding that a final judgment is final as of a date in the past simply because it could have been entered is not how other courts and not how other jurisdictions interpret that rule.
Would it be obviously, the court used nunc pro tunc, a little bit of Latin there, which there's jurisprudence on that. What if the judge simply wrote on the decision there, yes, today is July 3rd, but I'm signing it today, but it was final as of June 6th, and this judgment is intended to reflect what actually happened on that date. If he said it out loud as opposed to simply using the nunc pro tunc language.
Still inconsistent with the state of banks, Your Honor.
Well, are you saying that you can't do a nunc pro tunc unless it's to fix a mistake or a ministerial error?
In an order that's essentially already been entered.
My understanding is that's how it's generally deployed, and I think when I looked into Maine case law applying the magic Latin phrase, that there are only a handful, if even a handful of decisions discussing that, and the traditional references there from the 19th century spoke to a case that was adjudicated in a prior term of the trial court, if they had terms, but then decided later. So there was the calendar of the courts necessitated the courts to reach back in time and say, well, we could have had a verdict then, we didn't. And those are the cases Russ v. Dow, 32 Maine 590, 1850 was the year there, and then there was an 1859 case as well.
Thank you, counsel.
Oh, thank you. I'll reserve the rest of my time, Your Honor. Thank you.
Oh, I wanted you to get those citations out there. Attorney Mason.
Thank you, Your Honor. May it please the court, I first want to point out that, I don't believe Maine law has an obvious conclusion here. I think there is a pretty clear gap. Jurisprudence certainly has been dealing with similar issues of abatement and timing of divorce, but I don't think there is a clear answer on this, but I think that there is a logical next step. And that logical next step really just involves drawing a distinction between contested cases and uncontested cases, because the substance of what a judge does following a final hearing is different depending on what happens on the day of the final hearing. Ultimately, what I'm proposing is that, to reiterate jurisprudence that this court has already ruled on in cases like Muther and Boland, is that on days where there is an uncontested hearing, the court conducts a full hearing, swears in all parties under oath, both parties provide testimony, unequivocally accept the court's exercise of authority and jurisdiction on that day, unequivocally agree to all of the terms that are needed to address or needed to be addressed in a divorce. The court accepts them orally and tells the parties that. The court orally tells them, you're divorced that day, and the hearing is concluded and there's no substance required from the parties or the judge at that point other than the filing of documents. I think that in those circumstances, the adjudication and the exercise of jurisdictional authority should be that day of that final hearing. And anything that occurs after that, whether the order is signed later that day because we had paperwork in on time, or whether it's 3 weeks later. Certainly I've been on cases where this process goes on for a year because the attorneys simply can't agree on the wording, even though there was an oral hearing. I think all of those opportunities for delay mean we need to draw the line somewhere. And in a divorce, just speaking from experience, I think a lot of parties would prefer the line is drawn sooner than the final hearing. But I think it's a logical thing to determine that the court's exercise of authority occurred on this day, June 6th, when this hearing occurred. Both parties were alive, and all matters of the divorce were fully resolved. At that point, it was a signature from the court that was needed. That didn't happen until later. So I think that if we use this measure in uncontested cases, it jives with and plays nice with Rule 58 in the state of Banks, because still, Banks was a contested case. The court had decisions to make after the final hearing. It makes sense that we use as a measuring stick the date of the written order in that circumstance. But in uncontested cases, again, it makes sense to say the divorce was over on the day of the hearing, but still, for Rule 58 purposes, timing of appeal, things like that, we're still saying that the date the written judgment was signed triggers the appeal periods and things like that. I think that doesn't contradict each one another, nor does it require us to rewrite any of the rules or authorities. Again, this fully adopts and embraces the line of cases
Well, I see
Muther,
that
Bull,
the
and
green light is on.
I'm sorry.
And so in the transcript, although the judge did say at one point that I will go down, look for the paperwork, sign off if there's waivers of appeal in the file, the divorce is judgment, divorce is final as of today. And you can get a certified judgment upon request. However, then after the judge said that, there was additional testimony, and it became clear that there were orders regarding real estate that would need to be prepared as part of the divorce judgment, and that were not available for the judge to go down and sign that day. I mean, doesn't that really undercut? And the judge basically says, okay, so you're going to prepare the real estate orders and get those submitted, and that was Attorney Susi. If you'd be so kind as to submit the real estate orders, I will then sign those, and that's part of the judgment. So the judge really didn't, may have started to say that it was final, but then really backed off of that.
I think that's partially true, Your Honor. I think that in terms of the process and the paperwork to say and to give these folks a divorce judgment that they could present to town office to show that they're divorced, or present to their employer to change health insurance, I think that that's true. There was still tasks to be done, but there was nothing substantive for the court or the parties to do.
Would you have been comfortable advising Mr. Carter he could go ahead and marry someone else on June 7th?
Oh, gosh, no. He was in no position to marry anybody else at that point in time. No, I think that marriage was the last thing on his mind.
Well,
but even then,
I meant as a legal matter, would you be comfortable advising him that he was legally free to do that?
I would have told him that, no, we needed a written judgment until,
Right.
because he needed to establish proof, which, again, written judgment is important for all kinds of things like enforceability, the timing of post-judgment motions, because with oral orders, it's very difficult to
And
file.
how do we ignore the terms of Rule 58?
I'm sorry?
How do we ignore the terms of Rule 58 that the judgment isn't effective until the signature, or if there's no signature for oral orders, it's entry on the docket?
Well, again, I don't think we are, Your Honor. So I think Rule 58 is really just focused on the timing of post-judgment procedural deadlines, and what I'm proposing doesn't disturb that. All of the deadlines will remain the same and will be triggered by the written judgment, but when we're talking about jurisdiction and adjudication, when a judge is actually exercising its authority, that's a different assessment and a different beast entirely, and that is a different date, which Rule 58 doesn't touch.
How do you step around the language of Banks versus Banks? The court's signature is the defining moment for a judgment's finality, regardless of the level of agreement between the parties leading up to the judgment. It really emphasizes and promotes the signature as being the defining moment.
I think that is difficult language, Your Honor, and I think that in that circumstance, The court was faced with a bunch of different questions that are wholly separate from the ones that we're faced with here, and it was facing a different timing in the divorce. You know, that court was focused on only the window between written judgment and docketing and deciding, okay, when are we going to say this is over and
Right.
parties can carry on?
Right,
But
and he emphasized that his language is very conditional. If there are waivers of appeal from both parties in the file, the divorce judgment and the divorce is final as of today. And as we know, only one waiver made it into the file in the meantime, so
that's right, Robert.
technically that condition wasn't met.
No, but waivers of appeal aren't a condition for the finalization of a divorce generally. You know, after the final hearing, a full appeal period, 21 days did run, not that that matters in this particular circumstance, but 3 weeks did go by without objection, without any filing. So I think naturally, had the order been signed that day, the appeal period would have run.
Can I ask you a question? It's a little bit off the topic we're talking about here. Is there any doubt that John died on June 27th? I mean, is this really an issue?
I wasn't there, but yes, according to the documents
But
I have.
There's no doubt in anyone's mind that occurred.
I didn't find out until after the court had issued the written judgment,
So
but yes.
we can assume that.
You can assume that he is
I mean,
passed.
I think following up on that, there isn't anything technically in the record in front of the trial court establishing the death. All we have is the motion brought by Ms. Martin that alleges that there is such a death, and then without letting 21 days go by, that motion was denied. Are you willing to stipulate for purposes of this appeal that the death occurred in that period of time?
Of course, yes, that would seem the honest thing to do, Your Honor. That is what happened, yes.
If we disagree with your reading of when there was a judgment, and if we say, there was no judgment until July 3rd, what is your argument that that jurisdiction didn't abate?
Jurisdiction didn't abate because there was nothing for the court, there was no exercise of jurisdictional or court authority between that period of June 6th and July 3rd, other than the signing of that document. There was nothing in the final orders that wasn't drafted by the appellant. Everything that the court signed off on is perfectly reflected.
But my point being that if we disagree with your view of that authority and say it's not until, there is no divorce until July 3rd. It's not really ministerial, okay, because there's no divorce until July 3rd.
Understood.
If that's how we look at this, is there an argument that that the court still had jurisdiction? What is that argument?
Yeah, yes, Your Honor, and under the same logic. So I did consider the nunc-pro-tunc arguments and sort of the retroactive application of this judgment. I don't know that that truly matters all that much, aside from the evidentiary issues with those arguments, because really I think what it comes down to is what was the timing that the judge said, I'm making decisions about your folks' rights and future, and saying, you guys are done here.
Does it depend on the nunc-pro-tunc language then?
I'm sorry?
Does it depend, does your argument depend on the nunc-pro-tunc language?
No, not at all. In fact, I would say that it doesn't. For what I'm arguing, I don't think it matters whether it said nunc-pro-tunc back to June 6th.
Well, we've been pretty persnickety about having to have a final judgment, haven't we, in our jurisprudence?
Absolutely.
That's an important event, and so it's either the signature or the entry on the judgment, and that did not happen.
That's right, Your Honor. And as the docket record will show, is that, or the trial record will show, is that that gap in time shouldn't have existed.
But that's not the test you want us to apply. You want us to have a kind of a floating test for when we consider that the substance of the divorce terms have been agreed on?
No, I mean, this court has already held that in cases like Muther and Boland, that when there is a comprehensive oral settlement, that becomes an enforceable order of the court.
Even if it's a conditional one?
I don't believe it was conditional in this case, Your Honor. The judge did say if waivers of repeal were filed, that the divorce would be final this day. I think that's true, but again, the divorce wasn't contingent upon the filing of those documents.
Are there any cases that would say that someone's death between the date that the judgment was put on the record and the date that the judgment was actually signed in a divorce case, the court retains jurisdiction to do that and that it does not abate?
Not in Maine that I'm aware of.
or anywhere. I wasn't finding anywhere.
Well, I think I referenced New York, which actually has a statute that deals with this
Right.
issue and embraces my opinion, but...
And I guess absent a statute that specifically says.
Yeah, I think Ohio, where co-counsel, I guess, is from, does not have a statute, and they have adopted this common law exception to the rule that I'm proposing, yes.
Can you help me? I know you've addressed this, but I'm still having trouble squaring the state of Banks, which I think you've acknowledged has language that's a bit problematic for your position, and Boland, which seems more favorable to your position. I think at the outset you suggested the differences between contested and uncontested. I'm wondering, is there a difference in your mind between enforceability of a judgment and finality of a judgment, and what difference does that make in your case?
Yes, and thank you for asking that question. Yes, I do think there is a difference between oral orders or the effectiveness of an order and the when it becomes enforceable, because, you know, again, oral orders are enforceable or effective as of when they're issued, but they are difficult to enforce until they're reduced to writing. That way the council has
But
something
isn't
to point.
enforceability really as between, in all of our cases, you know, from Cloutier or Boland, whatever, talking about settlement agreements, when we talk about the enforceability, we're really talking about as between the parties, aren't we?
That's right, Your Honor, yes.
Terms as between the parties.
That's right, Your
And
Honor.
that it's enforceable by incorporation in a divorce judgment.
Yeah.
So if the parties agree on the record, the judge hears it, okay, if you agree, okay, that agreement is a done deal. They have a hard time challenging it after the fact. And that agreement is to be incorporated into a judgment that is issued. So they don't enforce that agreement until a judgment has issued. So that implies that there's another time period where the court still has the case pending before it, and then according to state of Banks, when that judgment comes down, that thing is ensconced in steel. But if the court has lost jurisdiction because one of the party passes away in the meantime, that jurisdiction disappears. That's the point that I'm trying to focus in on.
I think that's true, Your Honor. I think that there's no perfect calculus here. I think that answers all questions in every case. But I think if we adopt and embrace the jurisprudence that the state has already, I think this is a natural next step. I think adopting appellant's argument would cause us to double back and say, oh, well, oral comprehensive settlements are effective except this. Or, you know, I think that we would then be diving into exceptions, chipping away at judicial authority, saying when non-proton can be used and when it can't. So I think it creates more problems than it resolves, even if maybe it is the cleanest or easiest application of the rule to just say, in any case, the date, the crucial date is the date of signing of this judgment. But again, in uncontested cases,
Does it
there's
matter
far too
what
much
the judge
game.
says at the hearing?
I'm sorry?
Does it matter what the judge says at the under your theory, at the uncontested hearing? In other words, I don't think judges every time say, okay, you're divorced today.
Right. Well, they try to. But I think, yes, absolutely. I think that what the parties understanding leaving that day is not to reach into their brains, but at least in terms of what's on the record, yes.
So if the judge says, yep, that sounds like a good agreement, I'm just going to review the paperwork, and doesn't say anything to the effect of you're divorced today, then different case?
It could be, yes. Yes, that's right, Your Honor. I think we would have to define criteria, and maybe that puts an unfair onus on the trial judges. But I think that what the parties and the judge understanding was leaving that day is extremely important. And I think that, you know, if we're going to continue to be an anomaly to the rule and favor integrity and honesty and holding people to their word and giving weight to what judges say, I think that this is the only natural conclusion.
Thank you.
Thank you, Your Honor.
And Attorney Woke, I believe you reserved 3 minutes for rebuttal.
I did, Madam Chief Justice. And the issue that I immediately want to jump on is the idea presented by counsel that a logical next step of this jurisprudence is effectively to overturn Estate versus Banks, redefine Rule 58, overturn the collateral progeny of Estate versus Banks, which includes the court's recent decision in Wineley and Chatfield v. Chatfield, or State of Chatfield. All these cases that rely on the finality of judgments rule to ascertain and to determine when courts, when jurisdiction may or may not be defined, when the courts may or may not have jurisdiction. The way I view the issue is that in asking to extend Boland to include the court's subjective decision about whether or not a settlement is enforceable even when personal jurisdiction or subject matter jurisdiction is lost, is creating far more problems than it would ostensibly solve, in contrast to the court maintaining a fairly rational principle of saying this is a personal matter between the two individuals who are litigating it. If a party dies, then so be it. Subject matter
But in this
jurisdiction is
matter,
lost.
everything had been nailed down. The agreement really covered everything. The parties thought they had an agreement going forward, but for the death, the signature really would have truly been ministerial. The judge was going to. It was a done deal, except for the technicality of putting wet ink on a piece of paper.
And yet the court has said that mere technicality is central to the party's understanding and the court's understanding as to when a final judgment is in fact entered.
But maybe an exception should be carved out here, where it's all nailed down, hook, line, and sinker.
Well, so I don't think the court needs to, two things to that, Your Honor. I don't think that the court needs to set aside Banks, Boland, all that progeny in order to achieve that goal. First, as a practice matter, the parties can try, the only times I've ever done it, we've gotten a written order the day of the agreement being read onto the record. So it is a practice point or a practice choice that could work in favor of the parties avoiding the court needing to weigh in on this matter.
In fact, they might have had they not realized, oh, we have all these pieces of real estate that we didn't do.
Or other issues to adjudicate, exactly, Your Honor, or to sort out.
Well, the waivers were still, at least one waiver was still outstanding at that point as well, correct?
What was that, Your Honor?
One waiver was still outstanding.
One waiver was outstanding as well, Your Honor. So again, and the court sees all the time that there might be an agreement, there might be even a final judgment, and parties find issues to litigate upon seeing the written final form of that ostensible agreement or judgment between the
So would you like us
parties.
to put a practice pointer in a decision if it goes forward to say, when you have an agreement, get the judgment as soon as you can?
And may I answer, Madam Chief Justice?
You may.
I think the court, in adjudicating this decision consistently with its past precedent, will implicitly be giving that pointer to all parties paying attention. Thank you, Your Honor.
Counsel. Thank you, counsel, for your argument here this morning. As is our usual practice, we will be taking the matter under advisement and not issuing the judgment today. No, and issuing a written decision in due course. However, it is also our custom, I understand, Attorney Mason, this is your first time in front of this court, so it is also our custom to invite all counsel back to take the greetings of the court in the conference room. We look forward to seeing you there. morning. Is it still morning? You can be seated. Sorry for the delays. We've had a couple of new arguers this morning, which always gets us a bit off track as we invite them back. The matter before the court is Penobscot 25-308, Danielle Nadeau versus Jason Neto. I see counsel are present, and I'm assuming ready to proceed. We are being streamed on the web, both by audio and by video. If counsel who are arguing would identify yourselves by saying your names for the record, please, together with the party you represent.
Lee Bowles for the appellant, Your Honor.
Kristen Murray James for the appellee, Danielle Nadeau.
Thank you. And Attorney Bowles, if you're ready to proceed, we'd be happy to hear your argument.
Good morning, Madam Chief Justice. May it please the court. This court should reverse the judgment of the trial court and enter judgment for Jason Nadeau. There are two compelling reasons why the court should do that. First, Ms. Nadeau's claims are barred by the statute of limitations, Title 14-752. This case does not fall within one of the statutory exceptions to the general statute of limitations. Appellant argues that the case falls within 752, argues that the case falls within 752-C, which provides exceptions to the general 6-year statute and imposes no statute of limitations for sexual acts toward minors. That argument doesn't work here. As set forth in our brief, to make it work, you have to establish that Jason Nadeau acted with criminal negligence. And the evidence and the conclusions of the trial court were that he did not. To act with criminal negligence means that Mr. Nadeau had to be unaware that Ms. Nadeau did not consent to his actions, and that's completely contrary to the evidence. In fact, in the appellee's brief, that point seems to be conceded when she writes, he persisted even when she did not consent. Nevertheless, she argues that criminal negligence does not apply because it is an attempt to graft a criminal beyond a reasonable doubt standard in a civil case. That, I want to be clear, is not our argument today. This is a civil case, and it's a preponderance of the evidence standard that applied to the proof of the plaintiff's claims. But as a threshold matter, in order to avail herself of the special statute of limitations, the court had to find that Mr. Nadeau acted with criminal negligence with respect to the consent issue. And that, as I say, was not the evidence. There's a second compelling reason why this court should reverse the trial court's decision and enter judgment for Mr. Nadeau. And that is that the plaintiff failed to prove her 3 theories of civil liability. With respect to negligence, there was no physical harm sustained, and that, I believe, is undisputed. Now, over objection and without expert testimony, the court admitted evidence that someone had diagnosed the plaintiff with PTSD. Who? We don't know. When? We don't know. What caused it? We don't know. PTSD is not a physical harm, although I think that in the case law there's some...
The green light is on. Let's assume that you lose the statute of limitations argument. Let's assume we agree that this case doesn't fit all the elements of each of the legal theories they articulated. But let's also look at, if we saw all the elements had been proven of battery, could we affirm, based on the conclusion that this clearly met and as found by the court, a battery tort?
No, because...
Where's your prejudice?
Well, the first prejudice is it would be barred by the statute of limitations. I think a battery claim, and that, by the way, Your Honor, probably was the most obvious claim to bring, assault and battery. But those claims were barred by the statute. I suspect that's why they weren't brought.
So why are those claims barred by the statute as opposed to a negligence claim?
Why? Well, I mean, the only claims that aren't barred by statute are if you can fit within sexual abuse toward minors. So the question is, what claims can you assert?
Right, but there's no tort of sexual abuse of a minor. I mean, we
Correct.
fit it into a tort law.
Correct.
And the tort would be a battery.
Correct. So I think the problem, for example, with assault, and I mean, this is sort of the deep dive.
Or
but
assault. I mean, we can use old-fashioned or assault, but.
Yes, but I mean, if you look at the 752D, you have to make one of those categories, and I submit that there's two potentially that they could have fallen into. There are assault claims as part of 752D, but the facts just don't match here.
An intentional touching is not an assault as well?
You'd have to bring yourself, Your Honor, within the language of 752D if you
Right.
want to bring yourself in the no statute world. And if there are 5 or 6 separate listings of potential claims that could have been brought. Some of those are arguably assault claims, but they require specific proof. So for example, 752C, gross sexual assault. I don't think when I went and looked at those actual elements for gross sexual assault, excuse me, they do not fit the facts of this case. I suspect that's why an assault claim.
I understand that, but I guess what I'm not understanding is that an unlawful sexual touching or unlawful sexual contact necessarily also includes an assault.
I don't know that it includes, I mean, are you asking me, would it include an assault?
I mean, I guess I'm not following why you think that, let me back out. I don't want to really argue about the criminal law so much, but I'm not following why you're saying that when one goes to put this in the language of a tort claim, which is what happened here.
Yep.
I mean, the claim in the tort, in the complaint is not for unlawful sexual contact.
Right.
The claim in the complaint here is for negligence in count 1, for a negligent infliction of emotional distress in count 2, and an intentional infliction of emotional distress in count 3, right?
Correct.
Okay, tort claims, in other words.
Correct.
Because we don't recognize these as separate tort claims.
No, and I didn't mean to suggest that sexual abuse of minor, I agree with you, is not a tort claim. It's just a vehicle that you can.
Right, to do the for the statute. But so I guess I'm unclear why a tort claim for a battery or assault, whichever language you want to use, an offensive physical touching, would not lie.
Because
If the statute of limitations wouldn't bar other claims. I mean, I understand that your argument about the statute of limitations.
Right, if I understand the question, but that is the answer. The answer is, I mean, when you look at the.
So are you not prejudiced if they just cited the wrong legal theory?
Well-
Getting statute of limitations aside,
Right.
would you have done anything differently if they articulated this was a battery instead of negligence?
You mean, would the evidence have come in any
Yeah,
differently?
would you have done anything? How are you prejudiced if we say statute of limitations doesn't apply, you disagree, but then we say, well, where was the prejudice just because they didn't articulate the right theory?
Well, I guess the evidence would have been the same, Your Honor, but I'm struggling with the question because an assault claim clearly is barred by the
Okay,
statute of limitations.
So now this is coming back to what I'm not understanding about your argument. Just assume, and I know you don't agree, but assume we decide that the claims as pled here are not barred by the statute of limitations. Are you saying, but a battery claim or assault claim would have been?
I think a battery claim, I think a battery claim or an assault claim, yes, would have been barred by the general statute of limitations.
Even if the claims as asserted here, negligence, intentional infliction, negligent infliction, were not barred?
Well, the only way the claims that are asserted here are not barred.
So I know you're not buying into the fact that they're not barred.
And I apologize. I just don't think I'm appreciation the court's question here.
What I thought I heard you saying, and I'll try to rephrase it because I really am confused. This is a question. This isn't an argument with you. This is what I think I hear you saying is that even if we decided that the statute of limitations under 752C did not bar the 3 claims that were asserted here, it would still bar a claim sounding in assault or battery.
I think so, because you'd still have to bring, if an assault claim, you'd have to find out where in 752C does that claim lie.
Well, assuming the assault was a sexual assault.
I think the only type of sexual assault, well, all of these are sexual acts toward minor, but the sexual assault you would have to bring yourself within would be 752C, 2C, gross sexual assault, which means you'd have to then comply
Okay,
with.
so I guess that's where
you're losing me as well.
Yeah.
The definition of assault is an offensive touch.
Correct.
So why wouldn't that fall under subsection E?
Or F.
Or F, excuse me. It's an
Because if you-
offensive touch. That's unlawful sexual touching, isn't it?
E and F require criminal negligence, though.
So can you,
that's a different argument.
if a person commits unlawful sexual touching, is there any way that would not be considered to be a common law battery?
Is there any way? Probably not, Your Honor. Probably
So
not.
Battery does slide in under the.
It does.
rubric.
Battery can't slide in because I submit battery. I mean, I think there's a reason the complaint was filed this way. I think the reason was because the most obvious theory of recovery here is assault. Yet we don't see assault.
In the
So
short,
that's kind
in
of
the
a
short
clue.
time remaining, what is criminal negligence? How are you defining criminal negligence?
I define it the way the legislature has.
And what is that?
Criminal negligence, the legislature says, to be criminally negligent, a person acts with criminal negligence with respect to the result of the person's conduct when the person fails to be aware of a risk that the person's conduct will cause such a result.
So it's basically
And here-
negligence.
I'm sorry?
It's essentially negligence, isn't it?
Well, except it's more refined in terms of the statute that the 752C cites because it specifically talks about consent. You got to add the consent key in because that's part of 752C. If 752C says go to the unlawful sexual contact or the unlawful sexual touching statutes, and you go to those statutes, and then you find that they're talking about criminal negligence in the context of whether or not the assailant understood there was consent or not.
Can I ask a question in the very short time you have remaining?
It was so fast.
It always is.
Flies right by. Section 752C draws from Title 17A for definitional purposes.
Yes.
So just directing your attention to 17A, section, I think you touched on this in your opening, section 34 sub 3, when the law provides that negligence is sufficient to establish an element of a crime, that element is also established if, with respect thereto, the person acted intentionally, knowingly, or recklessly. That's that, if it's, the low level of burden, the ones up above it still apply.
Right. And I actually addressed that in a reply brief in a footnote, but that, to me, that's a trap that we should not fall into. And the trap is we are not proving a criminal case here. This is for a purpose of a statute of limitations analysis. So you don't then start saying, well, if you have criminal negligence, can that be subsumed in recklessness? That is not the correct analysis because we're not proving a criminal case. We're simply following the wisdom of the legislature in having changed this statute and said, this is how you look at the statute of
May I have
limitations.
leave just for one follow-up?
Go ahead.
So you say we're not proving a criminal case here, but you are working with a definitional term from a title in which it also enhances that definition by section 34 sub 3. I mean, it's not a criminal case, but
It enhances it for purposes of if you have to prove a criminal case. But I don't believe you have to do the analysis when you say, what is criminal negligence and is it here? You then do a further analysis and say, well, can we enhance it by looking at the other standard? I mean, at some point, and I made this argument and did not assert this on appeal, but at some point, my client needs to avail himself of the protections of the criminal law if we're going to try this like a criminal case.
may I have to leave for one very brief
Go ahead.
follow-up? So, but the argument you're making to us is, we're drawing from the criminal law for the definitions of when the statute of limitation operates, and that same title has this 34 sub 3. So you are suggesting that the legislature's intent was, for criminal matters, that if negligence is required, it still is proven if the person acted intentionally. But on a civil case, there's less protection. So if the person says, no, I didn't do this negligently, I did it intentionally, that the legislature intended to carve out that anomaly?
It baffles me to some extent what the legislature was thinking. We know they changed it, and here's what we know about the change. The change is we're adding a mens rea element. So that wasn't there before. So now they say, but did they also say, and in thinking about that mens rea element, then we can decide, oh, is that subsumed in maybe a higher mens rea? I don't think we can go, that's a bridge too far, I believe, from a legal analysis, Your Honor.
Thank you.
Thank you.
Attorney Murray James.
Thank you. Good morning, Chief Justice Stanfill, members of the court, and may it please the court. We are here today because the appellant is asking this court to disregard years of progress made by the Maine legislature toward expanding access to justice for survivors of childhood sexual abuse. First, by attempting to turn that legislative intent on its head and make it more difficult for survivors to bring civil claims. And second, by asking this court to second-guess the clear factual record established by the trial judge. The appellant's interpretation of the Maine legislature's expansion of the civil court procedure statute, removing the statute of limitations for sexual acts towards minors, is quite frankly remarkable. Over the years, the legislature has fought to broaden the scope of this statute to include more acts of sexual violence against minors. The 2023 changes expanded this statute to include sexual exploitation of minors, unlawful sexual touching, and incest. The clear goal was to ensure that those who intentionally prey on children can no longer hide behind the passage of time. It's a curious logic to suggest that the legislature opened the courthouse doors wider, only to build a higher wall immediately inside the foyer. To claim that a statute designed to increase access to justice was actually intended to make that justice harder to obtain isn't just a misreading of law. It's an attempt to undermine the hard-won efforts to protect children. Regarding the facts, the appellant faces the formidable clear error standard. We have a 9-page transcript where the trial court did its job. It weighed credibility. The judge looked at the parties and was blunt, telling the appellee, I believe you, telling the appellant, I don't believe you, and concluding it wasn't even close. The appellant now asks this court to rule as a matter of law that a 37-year-old adult man grabbing a 16-year-old's vulva and manipulating it for his sexual gratification repeatedly over a 3-hour period of time somehow fails to reach the threshold of physical harm. This argument ignores both the physical reality of the encounter and the common sense findings of this court. The trial court heard the testimony, evaluated the witnesses, and applied the law exactly as the legislature intended. There is no error here, let alone clear error. We respectfully ask this court to affirm the trial court's ruling on all counts. I'll take any questions.
Okay,
Thanks.
I was going to say, are you waiving your protected
So
time?
why didn't you include assault battery as a part of your tort list of legal theories?
Probably insurance coverage.
I can appreciate that, and that's one way we could have charged it. We decided to charge negligence, and the breach of the negligence was the breach of the duty, rather, was the sexual assault.
Well, that's a problem, because, I mean, the whole point of a negligent infliction of emotional distress is to actually circumscribe the circumstances under which negligence will suffice when the only harm that is alleged is not literally physical harm, but the emotional trauma. And that's not undermining the emotional trauma, but you can't, how can you use a negligence claim to expand who might be liable and under what circumstances the person might be liable over what we have said are the limits of negligence liability when the only actual harm alleged is the emotional trauma?
Well, our argument is that that's not the only harm alleged.
What is the physical harm that's alleged?
The physical harm is the grabbing and manipulating the 16-year-old.
It's offensive in terms of a battery, which doesn't require assault, depending on whether you're using our modern-day language or traditional language. But it doesn't necessarily cause physical harm to the person, and I don't think there was any testimony that it somehow caused her physical harm.
It does cause discomfort. It could cause pain in
You said
in
it
the
could.
row.
Is there testimony that it did?
She was not asked that question at trial.
Okay, but that's a problem.
In Roe v. Bennett, the issue of tactile contact was raised, and what
But
this
Roe
court...
v. Bennett talked about what the special relationship was, and now you're back into negligent infliction of emotional distress. And I'm just talking about a basic negligence claim.
Right, and my argument is that tactile contact does equate to physical harm, and there certainly was tactile contact.
But the court didn't make a finding of physical harm.
The court, and of course I can't get in touch inside Justice Maloney's head, but our belief is that that was just assumed, that a sexual assault is a physical harm.
I don't know why you would assume that. I mean, the cases you're talking about, I think it's very clear that Roe versus Bennett, for example, it may be tactile, but it is based on the unique nature of the psychotherapist-patient relationship with the duty of care in that context.
Well, I think in Roe v. Bennett, they weren't saying that there was tactile contact.
Right.
They were saying that if there had been tactile contact, that would have been an independently actionable tort that was objective evidence.
Can we move on from that into the negligent infliction? How do you define, I mean, it's unclear to me what Justice Maloney was saying was the special duty of care or special relationship that gave rise to the duty of care for a negligent infliction of emotional distress claim.
The language that he uses in his colloquy references the fourth part of the restatement, second 314A, which is the restatement that tells us that one who is required by law to take or who voluntarily takes the custody of another under circumstances such as to deprive the other of his normal opportunities for protection is under a similar duty to another.
He didn't really articulate it that way, though, did he?
He didn't articulate it specifically that way, but he did talk about the facts of this case as fitting into that type of definition.
So we cite that as essentially a temporary custodial relationship, as we did in the Nideck versus Camp Sunshine case, and you're saying that that's what has occurred here, and that's the basis for the NIE.
Well, a temporary relationship that was taken as a responsibility by a person who had more power over the other person.
But was it actually delegated, was custody actually delegated to him in this case? As opposed to when you send a kid to camp?
An inference could be made. They were in the middle of a family emergency, and both the appellee and the appellant were traveling from one hospital to another,
So she's being driven in a car. Are you saying that any driver, Uber driver, taxi driver, has a special relationship?
Absolutely not, no. I don't think we need to expand.
Then what is it
special
in addition
relationships.
to putting her in a confined car where she can't escape? Is it because they're related to each other?
I think it's a fact-intensive analysis. We have...
Well, who decided she was going to ride with him?
He offered her a ride.
Okay. Did her parent delegate, say, here, take care of my kiddo?
The appellee's father was at the hospital, and he knew that the older cousin was going to be driving the younger cousin.
But there wasn't like a specific conversation between them about it?
Not that I'm aware of.
So I'll ask my question that I asked. If we think, well, it doesn't really fit any of these legal theories, but it looks like all the proof and the findings would fit battery assault, do you think we could affirm on that basis?
I do, because the emotional harm would follow from that.
But could we affirm on the basis that we find it is battery, it was an intentional tort, you may have cited the wrong theory, but we will find no prejudice to the other side and do a post-judgment Rule 15 amendment to the complaint to include a battery complaint?
I'm not sure that that's completely necessary here, but that is one avenue.
Well, does that intrude on your prerogative? I mean, obviously, you made certain decisions as to what to bring here, and we don't need to know those, but those are strategic decisions. And to say, if theoretically, if those decisions didn't work for you, to grab something out of thin air and say, oh, by the way, there's an allegation here that wasn't, a theory that wasn't alleged, but you lose on that too, that's problematic too, isn't it?
That would be problematic.
Can we go back to the physical harm issue and your argument that the fact of the sexual assault itself was essentially the harm? Do you have any, I mean, I understand sort of the emotional appeal of that, and as Chief Justice said, it's certainly offensive physical contact. Do you have any cases, though, that stand for the proposition that the unwanted sexual contact itself is the harm, absent any evidence of injury that resulted?
What I am going to cite to is not a case, but it's the restatement, the language in there, that bodily harm, physical harm, is any detrimental change to the physical impairment, and that is sufficient for liability, and there's no minimum impact.
You said any
required.
detrimental harm to...
Any detrimental change to the physical impairment is sufficient for liability, and there's no minimum amount of harm. So our argument
So what would the detrimental change be in this case?
would be the moving around of the genital area of a 16-year-old, manipulating that delicate tissue.
But you agree that there was no further evidence about whether that caused her any symptoms or pain or anything of that nature?
That's correct.
So you're relying just on the fact of the Mr. Nato's actions, basically, to establish physical harm, is that right?
Yes.
Thank you.
I'd like to focus for a moment on the intentional infliction claim and the damages, or our jurisprudence requires that the injury, so to speak, or the effect be so severe that no reasonable person could endure it. There was no expert testimony here. There was no definitive testimony about the diagnosis itself. I'd like you to comment on obviously you're framing this as a clearly erroneous standard that we have to obey or enforce, and the court did make some findings, but it was fairly thin evidence, wasn't it, on that point?
I respectfully don't agree that it was thin evidence. The way that the evidence came in, and Justice Maloney said this on the record, that he would have appreciated some expert to testify, but according to, in case law, that's not completely required. The enormity of the outrage, if the enormity of the outrage carries conviction of severe emotional distress, the trial court can find the conduct extreme enough for intentional infliction of emotional distress and for
So you're
punitive
really
damages.
hanging your hat on the nature of the conduct rather than the damages?
I am, Your
rather
Honor.
than the nature of the emotional distress?
Yes. I think if we were ever going to say that a conduct was outrageous at this level, it would be a sexual assault.
If we were to find that the court erred in finding one of the theories of liability but not the other, what's your position on what would need to happen next? Would we need to remand for reassessment of damages?
I don't believe so. On the record, the judge was clear that the damages were concurrent across all counts.
Can I take you back to the special relationship again? Basically, you say he volunteered to transport his niece from a family emergency back to Bangor, correct?
From one hospital to another hospital, yes.
All right. And is there any other aspect of, beyond them being family members, that would make, that you say would characterize or crystallize that special relationship?
Thank you. Yes, there were other indicia that included the age difference, the fact that he was driving and she was a passenger, that the testimony said that his arm was over the lock. It was in the middle of the night during a snowstorm. She was deprived of her usual protections by being in that car with him. And
Isn't that true anytime somebody rides with somebody other than a parent?
I don't know.
Well, I mean, what I hear you saying is describing a situation that, basically she was trapped in this car, and I haven't heard anything about what you just described other than the fact that they're cousins, okay, that would apply to any situation when a minor rides in a car with an adult.
It's not just that particular, exactly the facts of being in the car together. It also is a recognition of the power disparity between the two and the vulnerability.
But again, why is that different here than any situation with a 16-year-old and a 30-some-odd-year-old man?
Because of what happened in that car.
All right, thank you.
Thank you.
And Attorney Bowles, I think you reserve 3 minutes for rebuttal.
Thank you, Your Honor. I'd like to try to make 3 points quickly in 3 minutes. The first is, what is particularly troubling on the intentional infliction claim is the court really found that there wasn't severe emotional distress, but then just elected to infer from the conduct severe emotional distress. And I think that's improper. You can't have a factual finding and then say, as a matter of law, I'm going to infer something contrary to that. With respect to the special relationship, I would say we cited in our brief the Richards versus Town of Elliott case where there was no special relationship when police officers actually physically took someone into custody. That didn't create a special relationship. And I would submit if that's not here, if that's not there, it wouldn't be in this case either. I guess most troubling that I'd like to revisit, and I'm wading back into these waters, is if I'm appreciating the questions that the court has about assault and battery, the really troubling part of that to me is that if you want to make an assault and battery claim or assault and battery claim, you still have to bring yourself within a sexual abuse of a minor or it's time barred. And what I'm submitting to the court, and I do feel, frankly, this is a little prejudicial, those claims weren't made. So if I saw an assault claim in a complaint that I had to go try, the first thing I would do is pull out the statute 752C and say, what do you need to show for gross sexual assault? That's what I would need to defend with respect to the statute of limitations. I never did that because there's not an assault being claimed here. Long ago, and no one, the court didn't oppose this, E and F were the applicable.
Isn't assault, from a criminal law perspective, it's a lesser included offense of several of those things?
The assault that you would have to allege to bring yourself within 752C is gross sexual assault. And my memory, Your Honor, and I didn't look at the statute before this argument, is that didn't fit the facts of this case. And if it doesn't fit, If it doesn't fit, that, I mean, it's, no, I'm not going to say that. I was channeling Johnny Cochran for a moment. I apologize to the court. But I just don't think you can do that. And it's very disturbing at this late day when the plaintiff isn't even moving to amend now to assert new theories that I now am confronting a new theory.
Well, that's why I want to know what the prejudice is. That's why I'm asking you, how are you harmed?
Fair enough. I guess the prejudice would be, I now would need to see what the argument would be to prevent a gross sexual assault claim, because I will represent to the court, it doesn't fit the facts. That's why I always focused on the other. I mean, some of them involve like, well, each of those has particular elements in the criminal code that would not have been satisfied in this case. Thank you.
Thank you. Thank you, counsel, for your argument here this morning. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we'll be in recess for the morning, I believe.
All rise.